Hello, and welcome to the Global Judicial Integrity Network podcast series from the United Nations Office on Drugs and Crime. Today's podcast will focus on the use of social media by judges, including common pitfalls, best practices, and a discussion of the privacy concerns associated with big data. Our speaker for today will be Judge Barry Clark of the United Kingdom of Great Britain and Northern Ireland.
Hello, my name is Barry Clark, and I'm delighted to be able to contribute this podcast to the Global Judicial Integrity Network's podcasts available online. I'll start by providing a little bit of information about my background. I qualified as a lawyer over 20 years ago, and I've been a judge for some years in the Employment Tribunal in England and Wales, and my current role is Regional Employment Judge for Wales. In that capacity, in addition to hearing cases dealing with allegations of unfair dismissal, discrimination, harassment, detriment for blowing the whistle, those sorts of things. I also act as a leadership judge for a group of salaried and fee-paid judges and members who work for the Employment Tribunal in Wales. I'm also a deputy chair of the UK Central Arbitration Committee, dealing with, among other matters, disputed applications for trade union recognition and other aspects of collective labour law. Finally, I'm also the National Director of Training for Employment Tribunals in England and Wales. In that capacity, I work with the committee and with the President of Employment Tribunals to decide what training should be received by all the salaried and fee-paid judges and members of the Employment Tribunal on areas of law as well as skills relating to judgecraft. I should say a few words about how I first became interested in social media as a topic for judicial training. Several years ago, I sat on a series of cases in which the outcome seemed to depend in some way, shape or form on something stupid somebody had said on Facebook or Twitter and the like. And it occurred to me that some of my judicial colleagues were not particularly familiar with how social media operated. As I began to think about the subject a little bit more, a number of other areas of relevance began to occur to me. And that resulted in me providing training on social media to various other jurisdictions in the UK, judges sitting in crime, civil, family and other areas, as well as other tribunals, and then afterwards in some other countries as well, and to conferences of Commonwealth judges and magistrates and international judicial trainers. It's been an interesting journey for me, and I can certainly say I've encountered a wide variety of opinions about the value of social media, ranging from those that think it's an essential part of judicial engagement to those who think judges shouldn't go anywhere near it, as well as a wide variety of experiences relating to IT knowledge, with some judges deeply uncomfortable with modern technology and others showing themselves to be at the very forefront of innovation. Perhaps that's not surprising when we consider how rapid some of the changes have been. I mentioned earlier that I'm from the UK, and taking the UK just as an example, I'm preparing this podcast in 2018, but it was only in 2007, 11 years ago, that Facebook launched in the UK and that Apple launched its first smartphone, the iPhone, in the UK. And smartphones and social media appear to have become quite ubiquitous in the years since. I imagine what my grandfather would have said if I'd told him that I can store in my pocket a small device with greater computing power than the Apollo missions, which is able at a touch to become our window to the world. Email, GPS navigation, photographs, messaging service, traffic updates, word processors, news consumption, and via the internet, the world's information available at a few touches. I suspect within a few years we'll be seeing these smartphone devices capable of being a major platform for paying for goods and services and providing diagnostic health services. In other words, they have become part of our fabric of daily life. And it's for that reason that I think that judges, whether they think social media is a good thing or a bad thing, have to pay attention to it. It simply can't be ignored. Social media has become one of the mechanisms by which friendships form, marriages form and end, business relationships form and are broken. The comments that people make online, which are preserved in aspect for eternity, so it seems, offer a rich vein of raw material for the cases that we as judges are asked to decide. If the stuff of life is out there online, it means the stuff of dispute is there too. And as judges of 2018 and beyond, we must become adept at understanding the way these platforms produce evidence for the disputes we must resolve. And if the fact that social media and the World Wide Web at large has become part of the fabric of daily life constitutes my first reason for judges needing to be trained on this material, the second reason comes from the level of analysis that takes place on the data that we produce. The smartphones in our pockets produce an exhaust of information that follows us, full of data that can be analysed by specialist companies that can spot patterns in the material we produce about what we do in our daily life. If you've ever followed a sat-nav app on your smartphone that shows you the colour of the road ahead of you going red when the traffic is busy, that simply means that the smartphones in the pockets of the drivers of the cars in front are showing that they are slowing down repeatedly by a pattern in that part of the road over several days and weeks and months. These footprints we leave online are analysed by advanced algorithms, repackaged and often sold for profit, and this has become known as the big data industry, and there's a whole branch of predictive data analytics that looks at this information and then offers statistical insights into the choices we have made and the choices we are going to make, including predictions about how we might spend our money, the entertainment we might consume, how healthy we'll be, and the cost of our health insurance, perhaps even how we'll vote. If you doubt the relevance of this industry to the work of judges, can I suggest you spend a moment on the website of the legal analytics company Lex Machina, which is the result of a joint venture between LexisNexis and the law and computing departments of Stanford University. This is but the first of many services that will be available to mine litigation data, revealing insights about the way particular judges think, how particular disputes tend to end up, and, who knows, perhaps one day play a part in judicial decision-making. The fact that this service exists and others like it is simply a reflection of the fact that a decade or so ago we began to produce so much more data by virtue of using smartphones for all sorts of things and joining social media platforms. And this brings me to my third reason for why social media is a good subject for training judges, which relates to online security. In the training sessions I've delivered to judges, one of the most impactful parts of the sessions has been where I've demonstrated the ready availability online of sensitive personal data about individual judges. I've asked judges to imagine that they finished delivering a decision in a case where one or both of the parties has been particularly challenging and might be tempted to look up that judge online for the purposes of harassment or perhaps simply an appeal based on the grounds of bias. Now, I can only speak for the jigsaw research, as it's called, that I've done in the UK, But using publicly available information from data aggregation websites, I've often been able to locate the judge's home address, the year or the precise date of his or her birth, and sometimes also the names of members of their family. Often I've been able to do this not simply because of the judge's online activity on social media, which often actually is not the case. It's more often because of the online social media activity of members of the judge's family, tagging that judge in photographs or identifying where they live or where they've just gone on holiday and so on. Additionally, in the UK, there is more information one can find from the records of Companies House, directorships and so on, charities, and in one particularly memorable case I was able to locate the park in which a judge ran a 5k race every Saturday morning, all done from the comfort of a desk. My point is this: judges carry out sensitive, confidential and often life-changing work, and as a result they need to learn how to protect themselves from intrusion into their private lives, which might result from unwise use of social media. But I think that as time passes and members of the legal profession join the judiciary in the years to come, it's more likely that those people will bring with them a digital baggage of social media activity from when they were teenagers, students, and so on. And it's important, therefore, that judges learn the importance of managing and curating that information and recognising that they themselves are, in the widest sense, tradable commodities in the big data world, as well as potentially individual targets of dissatisfied litigants and others. Some of the recommendations I make to judges are to find out what information about them is public and remove or amend it where possible, making every effort to ensure that their home address and telephone number are not available online. I also suggest that when judges sign up for online services, they enter the minimum amount of authentic information possible, thus making it more difficult for those engaged in jigsaw research to find out where they live, the name of their children, their pets, their mother's maiden name, and so on. For those judges who don't use social media, I suggest they protect themselves by speaking to and educating those in their family who do, and if they do use social media, to use common sense, to check who can see what they post. Their friends of friends, anybody? I also suggest that they should refrain from announcing online their holiday plans or a house move, and also to be careful of the photographs they share, and to ask friends not to tag them in photographs that might not be entirely in keeping with the dignity of judicial office. All this stands alongside the standard advice on IT security that gets issued to people whether they are judges or not, such as checking the default settings of websites and browsers that they use, changing passwords regularly, maximising privacy settings on smartphones, and using a shredder for disposing of private mail. If I ever come to deliver a training session in your jurisdiction, you don't want to be that judge I am tempted to pick on by doing some internet research, finding out where you live, and then trying to draw predictions about how you might decide a case from the people you follow on Twitter. So, be cautious, be sensible, and be wise. The next reason, and my last reason why this stuff is important for judges, relates to judicial conduct. It's probably not surprising for me to say that, like everyone else, judges are human beings, subject to the same impulses towards risky behaviour as normal human beings. In this context, it's worth posing and trying to answer the question why people say and do such stupid things online, and why judges might be tempted to do the same from time to time. And the first reason is that social media communication, in my view, uses a much less formal style. It's much more like a casual conversation less filtered, uninhibited, perhaps ill thought out. Another reason is that social media communication often exhibits narcissistic or attention-seeking elements, perhaps related to the low feelings of self-esteem among those using it. There is a burgeoning field of psychological research around the relationship between social media activity and self-esteem and the tendency of people to project false versions of themselves online. There's a case that was heard in the United Kingdom back in 2011, and the judge, Mr. Justice Mackay, commented in the case of R&D that the complex mixture of motives which impels people, especially young people, to post messages on such sites includes, the court suspects, the desire to attract attention, admiration from peers, and to provoke the interest of others in the person posting the material. We suspect that objective truth and the dissemination of factual evidence comes low on the list. Another reason is the ubiquity of the devices by which social media content is accessed. Not so long ago, a person's irritation with a colleague at work might not survive a good night's sleep, not long enough to use a typewriter to prepare a document to be placed on a public message board in the workplace. Now, however, an ever-present smartphone might mean that a comment is made online in the heat of the moment, perhaps with less awareness of who might read it, resulting in dismissal. These are devices which, astonishingly, people touch an average of 2,500 times a day. An average person responds to a text message within 90 seconds. Many will look at their device within a few minutes of waking up. Which relates to another reason for people often saying and doing silly things online, which is the addictive nature of the devices and the social media apps they contain. The notification badge is coloured red for a reason. It's a trigger colour. It's almost as if they are designed to be addictive. And these four reasons combine to form a toxic brew. It provides an opportunity for people to engage in unfiltered comment. And that, I think, helps to explain some of the very strange evidence that we see in cases from people saying unwise things online. As judges, we would do well to bear these features in mind when criticising parties for their online conduct, but we should take note of them for the purpose I mentioned a moment ago, which is that as human beings, judges are not immune to those same impulses. Against that backdrop, what sort of guidance can be given to judges to ensure that they behave appropriately? A good place to start, as always, is with the Bangalore Principles. And although they were first put together in 2002, those principles provide a workable platform on which to construct guidance around the use of social media in 2018. The 6 Bangalore Principles are independence, impartiality, integrity, propriety, equality, and expressed as a single value, competence and diligence. In respect of each value, a principle is expounded, followed by examples of its application. In the context of online conduct, I think it's the 4th value of propriety that is most pertinent. The principle says that propriety and the appearance of propriety are essential to the performance of all the activities of a judge, and the examples of its application include the following. As a subject of constant public scrutiny, a judge must accept personal restrictions that might be viewed as burdensome by the ordinary citizen, and should do so freely and willingly. In particular, a judge shall conduct himself or herself in a way that is consistent with the dignity of judicial office. A judge, like any other citizen, is entitled to freedom of expression, belief, association and assembly, but in exercising such rights, a judge shall always conduct himself or herself in such a manner as to preserve the dignity of the judicial office and the impartiality and independence of the judiciary. It's clear that the highest standards are expected of a judge on and off the bench, by extension in respect of his or her digital life. So this brings me to my next point I've been asked to address. Does this mean that judges should not engage in social media at all? Should there be a blanket ban? I would suggest not. That would be too onerous and intrusive a requirement. A person becoming a judge today could no more divest themselves of their social media life than they could divest themselves of the ability to shop or bank online or consume news and entertainment services online. In any case, requiring judges to abandon their digital lives upon appointment might lessen their effectiveness as decision makers. The British judge Lord Denning once said that if we never do anything which has not been done before, we shall never get anywhere. The law will stand while the rest of the world goes on, and that will be bad for both. Now, although that was in a very different context, those words have some resonance here. In a case before the state of Texas, the Court of Appeals, 5th District, commented that allowing judges to use Facebook and other social media was also consistent with the premise that they do not forfeit their right to associate with their friends and acquaintances, nor are they condemned to live the lives of hermits. So if a blanket ban is not appropriate, the question changes to this. What level of social media use is consistent with accepted norms around judicial ethics? I'm going to suggest a few guidelines that can be developed from the Bangalore Principles and which might offer a sound basis for future discussion. Ultimately, individual jurisdictions will need to decide how and the extent to which they prepare their own written policies on such behaviour. But these principles might offer a good start. First, unless running an authorised blog, for example one intended to demystify the work of the judiciary, do not use your personal digital life to publicise your appointment as a judge or your work as a judge or to identify yourself in a judicial capacity. I've acknowledged there that there may be an exception which comes with demystifying the work of the judiciary, where I think there is a space for using social media as the medium of engagement. But as I said earlier, this has to be done with caution and wisdom. Secondly, I suggest that judges should avoid expressing views online that, if it were to become known that they held judicial office, could damage public confidence in their impartiality or in the impartiality of the judiciary in general. There is often talk of the importance of the separation of powers and how politicians should be wary of interfering in the work of judges, and similarly, in reverse, judges should be wary of pontificating online about political matters that might cast doubt upon their own impartiality. The third piece of advice I might offer is that judges should be wary of following or liking online particular advocacy groups, campaigners or commentators, if association with their views could damage public confidence in their own impartiality. Although that said, if judges do want to follow certain political commentators, there might be merit in avoiding creating your own echo chamber by ensuring a breadth and diversity of views by following people with whom you might disagree. A fourth piece of advice, or principle to apply, is a more obvious one perhaps, which is to avoid expressing views online that are indicative of prejudgment of an issue of fact or law. This means not commenting on actual or pending cases, whether they're your case or another judge's case. It means not engaging in private exchanges over social media sites or messaging services in respect of such cases. And it certainly means not posting comments on websites in support of your decisions or the decisions of other judges. A fifth piece of advice I would give is to avoid looking up the parties online or engaging in private research in respect of their digital lives, easy though it may be and easy as it is becoming. This is simply an extension of the rule that a judge should not engage in independent investigation of the case unless the particular rules of the jurisdiction require it. What I'm suggesting here is that judges don't use social media to indulge idle curiosity. Sixthly, I suggest that judges should be circumspect in tone and language, professional and prudent in respect of all interactions on social media sites. This might be a good approach, to consider in respect of each comment or photograph what might its impact on judicial dignity be, and treat others with dignity and respect too. Do not use social media content to trivialise the concerns of others. Behave in a manner that promotes a safe and healthy working environment. Seventhly, consider whether any pre-appointment digital content might damage public confidence in your impartiality. If it does, consider taking advice on how to manage and curate that content. Eighth, be wary about extending or accepting friend requests to and from lawyers or representatives who may appear before you. The risk is that the connection might suggest a degree of leverage that a lawyer has over a judge in the sense of being in a privileged position to influence them. Such an online friendship will not always be a disqualifying factor, but it will be a matter of degree and perception. Finally, I would suggest to any judge who has had the unfortunate experience of being insulted or abused online to seek advice from senior judicial colleagues and not to respond directly. I once heard a Ugandan judge give advice to colleagues along these lines. Move on, because the judiciary is there today and will still be there tomorrow, and do not argue with a fool, because people may not be able to tell the difference. So, bringing all these points together, creating a modern, diverse judiciary for 2018 and beyond, which is properly reflective of the societies served by judges. What should we do? In my view, judges should be familiar with the ways that technology and social media and the big data industry are transforming all aspects of life. And if judges choose to be aloof from social media services, which is an understandable, admirable, but increasingly difficult aspiration, they should at least be aware of the influence of those services. And if they do choose to engage, judges should do so with their eyes open, and they should proceed with caution, aware of the security risks that arise from their digital footprints, and with the benefit of guidelines around appropriate online behaviour. Done properly, jurisdictions around the world should be developing social media guidelines that addresses judges' behaviour online and gives them the sort of tips I've identified for how to behave. Effective judicial training is, after all, essential to protect judges and to maintain compliance with ethical standards. But used properly, a judge should still be able to interact appropriately with their friends online, whilst official social media platforms could be used to contribute to transparency, open justice and judicial accountability. Taking these steps, I hope that judges will have their eyes wide open as we approach our next big technology-related challenge, which is how machine learning and artificial intelligence will influence judicial decision-making, but that will be the subject for an entirely different podcast. Anyway, thank you very much for listening. I hope I've given you some food for thought, and I would encourage you to spend some time browsing the resources section on the website of the Global Judicial Integrity Network. If you use social media as your search string, you will find a wealth of guidance materials and articles on the subject, which will help you develop your thinking on this most important of subjects. Thanks for your time.
Thank you, Judge Clark, for taking the time to share your expertise with us. You can access additional sources about the appropriate use of social media in the resource section of our website by visiting unodc.org/JI. To everyone listening, stay tuned for our upcoming podcast in this series of the Global Judicial Integrity Network.